court is now in session. All persons having business with the court draw near, give your attention, and you shall be heard. God save this court and this world. You may have a seat.
All right. Good afternoon, everyone. Thank you all for coming today. We are here on case number 230538, Part 3, Brewer et al. Versus Metropolitan Government of Nashville et al. All right, so before we get started this morning, I'm going to set the ground rules of how this is going to go today. Thank you to everyone for being here again, and give me just a moment to pull up my notes. All right, if you all will bear with me, one of the benefits of having two computers and two systems is you pull certain things up on one computer and then you come out here and it's not up on the other. But I will take the opportunity to introduce our wonderful interns. Every summer in Chancery Court Part 3, we invite interns to be with us during the summers. So we have Alicia Van Hoosen, who has been with us for quite some time. She is interning in the back this morning, but we have with us Victoria Madu, if you would just wave. Victoria is an intern with us from the Nashville with the Metro Youth Summer Empowerment Program. Journey Miles, no relation, is an intern with us also from the Youth Empowerment Program through Metro. And then Samantha McCory is a rising 2L at Belmont College of Law, who will also be joining us today. All right, so I want to set the ground rules for today. I understand that there have been some briefing filed, particularly by Mr. Horowitz in this matter, and when you filed a motion to set aside, and I denied that motion to set aside for ripeness, I do not believe that we are here today. We are not there yet in regards to the arguments that you presented in your motion. Not necessarily saying that we won't get there, but for right now, this court needs to understand what has happened in this case. Last week, I was prepared to issue a 60-plus page ruling on the ins and outs of this particular case. This is not your typical open records case. There have been some nuanced arguments presented before the court that the court really had to look into. And I was ready to issue my ruling when I was informed that perhaps something had come about in this case. And this court is not, I don't investigate, I actually sit as a neutral arbiter of the law. And so before I can go on, I need to understand if there is a live case in controversy for this court to actually rule upon, or if there have been such a significant change in the underlying facts of the case, in essence rendering the opinion moot. And because I don't watch the news, I don't do my own investigation, it's best that I have the attorneys to come in and really let me know what is going on. Depending on what I learned today from the parties, I will issue a separate ruling in regards to what the next steps will be. And at that point in time, perhaps certain documents that have been previously filed with the court will be ripe for adjudication. But at this moment, I would like to hear from the parties in regards to what is happening and what has transpired in this case. I put down an order earlier last week in regards to some information that was presented to the court, but again, the court does not go on its own fact-finding mission. It's really up to the parties to let me know what has happened, and frankly, if this is a live case in controversy, the Supreme Court does not like courts to rule on hypotheticals, and so I'd like to hear from the parties in regards to what we are doing today going forward. And so the order that I will take things in, well, I will hear from the respondent, then I will hear from the petitioners, and then lastly I'll hear from the interveners. Okay? Ms. Fox, are you?
Your Honor, just briefly before we get started on this, I want to interpose an objection. An inquiry into whether there is a live case of controversy is materially different from what this court's show cause order said, which was...
Mr. Horowitz, I put down a subsequent order, and in that subsequent order, which denied your motion to set aside, I set forth what we were doing today.
I understand, but I need to know if I'm here to show cause to determine why the alleged publication of certain reported documents by petitioners does not violate the orders of this court. If we're doing something else entirely, I need to know that before I present.
Well, Mr. Horowitz, as I said, I did not believe that your motion was right. And so before the court can make a determination if there has been a violation of the orders of this court has to understand what has happened. And as I said before, I don't go on my own investigative mission. So today, I'm going to determine what has happened outside of the document. I know respondents got some documents, and this court has documents. I don't know what has happened, and so I would like to have the parties in the underlying case educate the court as to what may or may not have happened. Depending on what I hear today, there may be a subsequent hearing and or motion where your motion would perhaps come back to life, and we would have a discussion in regards to a show cause or contempt hearing. But right now, I have to understand first what the landscape is. And that's what we're going to do. Okay?
We know our objection to the record.
All right. Thank you. All right. Ms. Fox. I am ready.
Yes, Your Honor. Laura Fox, representing the Metropolitan Government. The Metropolitan Police Department has been focusing its efforts on finding the source of this leak, and the declaration that was filed on Friday morning of Lieutenant Alfredo Aravello explains what has happened from MNPD's perspective as far as Mr. Davidson having access to these to this file, and then I think we referenced the articles that have appeared referencing contents of that investigative file. It does not appear that the entire investigative file has been released in any way, and so from the Metropolitan Government's perspective, this is still a live controversy.
Okay, so are you, and thank you for putting in the declaration of Lieutenant, is it Alvarero? How do I say his name?
Aravello.
Aravello. Okay, so thank you for providing the court with that declaration. So based on that declaration, well, and I will ask this frankly of everyone, have the actual documents been released? Is it a summary? You know, I guess what is the universe of the leak? If you could educate the court a bit.
The newspaper articles reflect at least 2 pages of the journal that was in the vehicle and being printed more or less verbatim, and then there are some quotes that have been released a little bit at a time, I guess perhaps on a daily basis.
So not everything, and roughly, can you maybe surmise how many pages? Is it just 2 full pages and then certain quotes? Is that correct?
Yes.
Okay. And have any of those documents been authenticated, do you know?
I think the declaration contains information indicating that they were correct.
Okay. All right. Okay, so having said that, is it your opinion, I guess, or if you can from your client's perspective, this is not the full balance of all of the documents in the investigative file. However, is there concern that these proceedings have the possibility of being interrupted or in essence, interfered with, should more documents and/or information come out? You know, this court sits, I'm over the process, right? And ensuring that the process is equal and just for everyone involved, including all of the parties. And so I would like some understanding and or clarity. Please silence all of your phones. If there has been or is there potential that this whole process can be usurped and or railroaded by what has transpired?
I don't know the answer to that. I do know that the amount of materials is certainly not the whole case at this point, and there are quotes taken that are not complete. And so I think that the court's ruling would both still definitely affect whatever the Metropolitan Government is able to release at the end of its investigation, which will be shortly.
Okay, all right. Thank you so much, Ms. Fox. Anything else? Anything else?
Sorry.
It's okay.
No, Your Honor, not at this time.
Okay, thank you. All right, Mr. Pierce, and I was going to make sure that I heard from all of the petitioners because I am not sure, again, the full scope of the landscape of this case as it now sits, and then who perhaps, if the allegations are in fact true, who has what and who doesn't, and who else thinks that, has concern whether or not this is a live case in controversy. So, yes, Mr. Pierce.
Well, Your Honor, I believe what Ms. Fox said is certainly true, is that there's only been 2 pages that have been shown on one news outlet here, and that constitutes a tiny fraction of what has been sought in this case. And so this case is still very much a live case under the Tennessee Public Records Act, which requires expedited proceedings. And, this case has been going on a long time. And so our position is this potential contempt proceeding has got nothing to do with the release of the records. And therefore, I would urge the court to quickly rule upon the underlying case. And one thing I was trying to confirm, when we had that couple of pages leaked back in November, Metro did very publicly acknowledge that those pages were authentic. They were, however, not the pages themselves, but somebody took a photo of the pages. And I believe that's what we have here, which is, once again, not even the pages. So, and Ms. Fox, I think it's come very close to saying that those 2 pages, once again, a tiny fraction, are authenticated. But that's the first time that I've heard that clearly, that those 2 pages, a photograph of those 2 pages might be authenticated. And so once again, I encourage the court to hurry up and rule on it consistent with the Tennessee Public Records Act.
Well, and I just want to remind everyone of the procedural history of this case. This case went up on appeal and came back down, and this court has worked very tirelessly on the many different arguments presented by all of the parties in this case. So I appreciate you, Mr. Pierce. Thank you so much.
I know you work tirelessly, and I do appreciate that, and all I'm saying is continue to work on this case, not on this alleged possible potential contempt matter.
Thank you.
And save that for another day.
Thank you, Mr. Pierce. All right, moving on. Anyone else from the petitioners other than, yes?
Good morning, Your Honor. Russell Nobile, Senior Counsel with Judicial Watch on behalf of the Hammond petitioners.
Good morning, Mr. Nobo.
We're in agreement with everyone else. This has just been a sliver of what's subject to the open records request.
Okay.
We do not think that whatever transpired in the publication should slow down the release of the merits ruling or change the ruling. However, the court was going to rule on that. I would just note that this is now the second publication of some alleged records from there, and there have been no copyright enforcement proceedings. And so to the extent there are copyright claims, they have not been enforced, and they've had more than an adequate time to enforce their rights. So this just bolsters the argument that this isn't subject to copyright, but we don't think it should slow down the release of the merits ruling.
Okay,
Thank you.
thank you. All right, anyone else from the petitioners? Mr. Horowitz, would you like to speak on behalf of, I know you're here on a limited purpose, and so you may want to reserve, depending on, you know, what the outcome of this matter is. But I believe, have I heard from all of the other petitioners? Is Mr. Hollow here? Good morning, Mr. Hollow.
Good morning, Your Honor.
All right. Just a moment.
Oh, I'm up.
Mr. Hollow, sorry, you were out in the hall.
Yes, Your Honor.
So hopefully, counsel for petitioners can squeeze in, so you won't have to retreat to the hall or across the way at the end of these, at the end of your addressing the court. So I'm not sure if you heard kind of, again, this court does not go on its own investigations, and so I thought it prudent to bring everyone in order to understand the landscape. And so I have asked the fellow petitioners, I spoke with Ms. Fox on behalf of the respondent first, and she referred me to the declaration of Lieutenant Alvarero in regards to the documents which I suppose have, at least were allegedly leaked, and whether or not those documents were authenticated. And then I've heard from several of the petitioners as to whether or not, given this new leak of documents, if there is in fact still a live case in controversy. You know, I don't know who has what. So from your client's perspective, please let me know anything that you would like to tell the court in regards to this issue, whether or not your client still feels like it's a live case in controversy, and if the ruling, in essence, would be mooted by what has allegedly transpired.
Well, may it please the court, I'm a little bit behind the curve as to what we're talking about this morning, because initially the order, as I read it, was a show cause order, and to those of us that do this occasionally, show cause order means come in and tell us why. And that's the way I was approaching this case.
Of course,
I see.
I will say, Mr. Hollow, in my subsequent denial, of the motion to set aside, I did set forth
Yes.
how we would proceed today. And, you know, there are certain procedural mechanisms that have to be in place when you are traveling down one road or another.
Yes.
And I am quite aware of those procedural mechanisms, and those were not in the first show cause for the exact reason that it was not a show cause hearing. I first have to understand the universe and the landscape before I can, you know, I'm not prosecutor and judge. I'm simply just judge.
Yes, Your Honor. The issue that comes to mind immediately upon looking at the circumstances as I see them, and that is that there were documents that apparently came into the possession of someone other than the court that contained materials that the court had in documents that it was looking at in camera as part of its review. And so from that point, the question was, well, what do we do about that? And because the court had specifically, I believe, 2 orders previously entered that said, don't talk about what we're going to be looking at in camera, basically. And so that puts us really puts us in a very, to my opinion, with apologies to everybody, it puts us in a constitutional dilemma. Because in Tennessee, we have a statute, which is, I think it was called the Free Flow of Information Act when it was enacted around the middle 1970s, which says that before anyone who is engaged in obtaining information for publication or broadcast, and Mr. Leahy, I think, would fall into that category.
Well, you know, with all due respect, Mr. Hollow, I am traveling right now under the presumption of allegations. I do not want to necessarily say someone has done something in violation. I will allow his counsel to perhaps educate me more. But I did tell, before you came in, I did tell Mr. Horowitz that in regards to any constitutional and or First Amendment arguments that were put forth in his motion to set aside, I did not think that those were ripe yet, simply because the court really has to ascertain where we are.
Yes.
Before I can say that someone has violated, they've done this, because it didn't happen in my presence. And so there are 2 different ways that we travel under. You know, if someone does something right in front of me, and that is one way.
That's direct contempt of court.
Yes, yes, and with this being more of an indirect contempt, traveling under Black v. Blount, you know, there's certain procedural mechanisms that have to be in play before we can even get to a remedy and or contempt finding, and we're not there yet. I first have to understand what happened.
And I understand that, Your Honor, and as I look at it, what happened is that in the old days they used to call it a transom package, because the newsrooms and newspapers all had transoms over the doors. And so when someone wanted to leak information, they toss it through the transom, and that's how the word transom package came into existence. And as I see this is very much like a transom package. Someone has come into possession of information which was otherwise not public, and it has come into the possession of the media or a person engaged in publication or broadcast. There's been no allegation that the person engaged in publication or broadcast broke the law in terms of a criminal violation by obtaining that information. So therefore, the information was lawfully obtained by the media. Once the information is lawfully obtained by someone who obtains it for publication or broadcast, then if we're going to try to find out where did it come from, who gave it to you, what was the source, if we would say, then we have to comply with the statute. And the statute is very specific. if someone is engaged in obtaining information for publication or broadcast, they cannot be compelled to testify about the source of the information or the information itself unless and until the court is determined by clear and convincing evidence that three factors exist.
Which is why we are not at that point.
That's correct,
today.
Your Honor.
Yes.
Because we don't know, and we can't ask the question. Because it gets into the issue, because you see, that's a privilege. It's a privilege that was established by the legislature. Interestingly, Your Honor, it's a privilege that came into existence because of the case of Brandsburg versus Hayes. And actually, the three-part criteria that we have in that statute, it comes from a dissenting opinion in Brandsburg. But that aside, we can't even say to somebody, where'd you get it? Who gave it to you? Because the statute provides that there's a mechanism for doing that. And here's the dilemma for the other side, Your Honor. If the person who has the information or obtained the information answers even an innocent question like that, then there's the issue of do they waive the privilege? In other words, if they provide any information to any of us, particularly to the court, without going through the three-step process that the statute enunciates, then we get to the question, did that constitute a waiver, and therefore the privilege evaporates into thin air.
Right, which again is why we're not there today. And
Right.
the court in and of itself, I appreciate those who read my orders very carefully and subsequent orders that come out to tell the parties what we're doing. That way everyone is on the same page. And so, again, the point of today is so the court can get an understanding of what has happened and what next steps should be, because frankly, I don't want to be overturned at the Court of Appeals. I actually really enjoy being affirmed at the Court of Appeals. And so therefore, procedurally, I am going to ensure that after today, whatever comes of this hearing today, that procedurally it is in order and that everyone is apprised of their rights so that we can move forward in a procedural manner. One thing I do want to understand from you, Mr. Hollow, is that you still believe that it's a live case in controversy. As far as your understanding of the landscape, you still don't have, you're still in the same position as you were prior to last week or the week before.
Yes, Your Honor.
Okay.
I have to say the answer to that is yes.
Okay.
Because I have not seen anything except some things that were on the internet.
Sure.
And so I don't know to what extent the information was. Did someone make a copy of the entire package of information that Your Honor has? And was that the subject of the leak, if you will, to use that vernacular? Or is this part of that information? If it was all of it, I guess we could say, well, that renders our question moot, then, doesn't it?
Well, and
Your Honor,
frankly, the court was concerned about that.
That's right.
So-
Because at that point, if everything that you have is now over here, then the argument is very clear. Yeah, it's moot. Because as the Court of Criminal Appeals said in the Zuman case, the cat's out of the sack.
Right.
And at that point, so I suppose that I'm limited, personally I'm limited, as an officer of the court, I'll tell you, that I don't see the information before me that would tell us we're at the moot point.
Okay. And that is helpful because, again, as I have said, the court has not gone on and looked at anyone's website. The court is busy on this opinion and some other opinions. And so I cannot sit as both judge and investigator. I have to just be the judge in this matter. So it's helpful to really understand where we are. So thank you, Mr. Hollow. Is there anything else?
No, Your Honor.
Right, thank you.
If you have any other questions, I'll do my very best to answer them.
Thank you. And please, I've asked counsel for the petitioners to kind of scoot in so Mr. Holler does not have to retreat to the other side. Mr. Noble spoke for you. So, Mr. Berry, do you plan? Okay. Mr. Horowitz? Okay. All right. So, since no one on behalf of, I've heard from all the petitioners, is that correct? Who plan on speaking today?
Correct, Your Honor.
All right. So moving on to the interveners, would you all like to educate the court on your position in this matter? Okay, and I believe Mr. Klett, I'm not sure if he's made his way into the courtroom or if he plans on.
I'm here on behalf of the school, Your Honor, as
Okay.
well. Mr. Klett is on his way. He got caught in traffic and then he couldn't get to the parking lot.
Okay.
He's on his way.
Okay, thank you. All right, good morning.
Good morning, Your Honor. Rocky King for the Covenant Church. To your direct question, is this a live controversy? The answer is yes, Your Honor. When we were preparing for today's hearing, through our own investigation of what was published by one of the petitioner's website, I believe the allegation is that only 80 pages has been obtained by that respective news outlet. I would venture a guess that you have more in your custody than those respective 80 pages in total. What those 80 pages are, Your Honor, unfortunately, we don't know. We only know what has been displayed on another news outlet, which appears to be 2 pages, presumably from those 80 pages. So unless the editor-in-chief or the Star would like to come forward and tender those 80 pages for in-camera review, there's no way for you to substantiate what there has been a mootness issue on, i.e. the 80 pages that have been leaked versus what's already in the court's custody and control. But from the Covenant Church's perspective, Your Honor, you have more in your possession than those 80 pages. And a ruling, as you already have with the court of the opinion that you've drafted, we would request to be published, because there are other issues that pertains to documents in your possession of whether the arguments raised by Metro and by the intervenors shield those documents from public disclosure. And as becoming more and more apparent, those individuals within the police department or individuals operating around the police department are thwarting the progression of this case, unfortunately. And an opinion on the merits would hopefully bring clarity of what the next steps are. And so those individuals that have operated outside the purview of the law and leaked to media outlets may not do so much in the future.
Okay. Thank you so
Thank
much,
you, Your
Mr.
Honor.
King. Mr. Osborne?
Thank you, Your Honor. Eric Osborne on behalf of the Covenant School Parents. Once again, I will acknowledge that the majority of people, at least in the back of the room, Your Honor, are Covenant School Parents who are here again because what has happened and what is happening matters so much to them and to their children. I certainly agree with Mr. King and all of the petitioners that based on what we have seen thus far, I have no reason to believe this case is moot. I certainly believe there are lots of important issues in this case that we would prefer that they be resolved by Your Honor and then addressed as they may be addressed on appeal as the case may be. One comment that I had intended to make, and that given Mr. Nobile's earlier comment, I feel merits comment, is that includes our copyright argument, Your Honor, which includes the right when you own documents to not publish them. And I don't believe there's anything in the record from anyone that contests the ownership that the families have of these documents, that they are ours, that they are subject to copyright. We have now 2 separate opinions from the AG's office saying that copyright is an exception to the TPRA, plus the AG's brief that we cited to Your Honor in a recent case. I find it very funny that anyone would say that the fact that the parents have not yet sued someone for copyright infringement means we have waived our copyright. There are such things as statutes of limitations for people to decide when they want to bring cases, if they ever want to bring them or not. But for the moment, this case, I believe, Your Honor, is very similar to the J.D. Salinger case that we quoted in our brief. where Mr. Salinger's estate had the right to not publish a lot of his materials. And probably everyone in this room has read The Catcher in the Rye. I mean, many Americans had a great interest in Salinger's unpublished works being published, and yet the court found that the copyright included the right not to publish, Your Honor. These are our materials. We own them. I don't own everything that has been referenced in the leaks, things that are police reports, I do not claim an ownership of. But it does appear that materials that my clients own have been taken and have been improperly published, Your Honor. And that makes this case far from moot. In fact, I would say we very much desire a ruling from Your Honor on that question.
Okay. All right. Is there anything else, Mr. Osborne?
That's it, Your Honor, unless you have any questions for me.
Okay, so this is a question just for, does anyone contend, that what has transpired has interfered with these court proceedings in such a way that it may be an abuse or unlawful interference with these proceedings, or is it that because it's such I don't want to say minor, but because there weren't as many pages, are we treading anywhere there? Ms. Fox, I will kind of go to you first, and then I'll allow anyone else who wants to speak on that. Again, this court sits as kind of the arbiter of the process, right? And so I want to ensure that every party in this case gets the justice that they are looking for by a fair and impartial process. And so do you have anything, and don't all rush the microphone, but happy to hear from anyone on that, and then I'll close out these proceedings.
Your Honor, Metro certainly believes that the person who leaked these documents has violated the spirit of this court's orders, and that is an abuse of the judicial process. I think the enforcement is very challenging in this case for several reasons. One option that we looked at possibly would be making Mr. Davidson an involuntary plaintiff pursuant to Tennessee Rule of Civil Procedure 19 and asking for an injunction that would require him to return the documents.
Do you contend that he is a necessary party pursuant to Rule 19, or just is he indispensable? And I'm happy to hear from everyone on that. And again, the court is looking at the process, right? Because the court is very concerned with, frankly, there are lots of open records, Tennessee Public Records Act cases across the state, and they all have a way that they are conducted. And so the court is concerned about a few things, that frankly, I don't know that I contemplated. I don't know that anyone sitting here contemplated necessarily. But if there is a gap in the way these types of cases, an opening, I think there has been light shown on an opening. The court has to look to how it can preserve, the proceedings for not only this case, but other cases. So when we think about this case in particular is, and again, I know that Metro is pointing to, but are they indispensable in your opinion?
I do not think he is an indispensable party, but I think he could be a proper party.
Okay. All right. Anything else on that?
No, Your Honor.
Okay. Would anyone else, Mr. Pierce, I have a feeling that Mr. Pierce is going to say, just get the ruling out and then you can deal with this stuff later.
Well, it's along that line, Your Honor. I do very much object to any suggestion about adding anybody else at this time. I don't think it was, once again, that goes to what I said earlier. These are two separate matters. If Mr. Davidson has anything to do with that leak, and I would suggest there's no evidence of that so far, there's only speculation, but if he has anything to do with that, that is the separate contempt proceeding, and that is not the underlying open records case that we have before Your Honor at this time. I mean, there is so much speculation about where these documents come from, and once again, the 2 pages that we're talking about that have come out recently, just like the ones that came out in November, what they appear to be is someone probably using their phone taking a photo of documents. And so Ms. Fox has suggested to you that after Your Honor issued your orders about things under seal, that then somebody had a leak. That has not been established. I think it's entirely possible that when those documents were taken, because the first one's in November, the indication is that they were taken on site on that day of that tragedy. They could have been leaked that day, long before these petitioners made our request, and so they came out long ago. That is certainly possible. And I would say the reason that happened, if it did happen that way, at that point a police officer may have passed it on to a friend, knowing that the chief of police of this city already said that these documents were going to be made available very soon, long before anybody requested the documents. And so if there was an officer that did that and got those documents out, that officer surely felt, well, no foul, no harm, because the chief of police said they're going to be released very soon. And so I just want to address that we don't need to be adding anyone else to this case. If someone needs to be added on a contempt proceeding, that's a whole nother matter. And it goes back to what I said moments ago. These are 2 separate issues, and we should not slow down the public records case for any contempt proceedings. And my final thought is I just can't help object to Mr. Osborne re-arguing his copyright issue, which has got nothing to do with why we're here today or answering Your Honor's questions. And I could stand up here and re-argue that as well, but I will just...
I don't know that re-arguing is going to help anyone at this point in time, because the court has ad nauseum reviewed all of the arguments presented in this case.
Well, I am not going to re-argue that, and I know that Your Honor has seen all those matters. So I think I made the position clear.
Thank you. All right, anyone else?
The court asked to hear from all the parties on it, so I'm just going to make our statement for the record. We don't think there's been an abuse or prejudice through the process to whatever the publications are. These are adversarial proceedings.
But is this really a traditional adversarial proceeding? And I'm not here to have a very long discussion with you today. You know, I think the Tennessee Open Records Act is a different type of act in regards to government and citizens. You know, it's not what we think about, at least in the court's view, as a typical litigation where we're adversarial. And so, again, to reiterate the court's concern is in cases like this, right, where you have specific documents that are held by a respondent and the court only until the court issues a ruling in regards to whether or not those documents, with all of the exceptions set forth by the legislature, you know, are actually open, you know, records for citizens of Tennessee. If actions like these are taken, does it compromise, you know, the process, even as contemplated by the legislature? The legislature set forth the process.
Correct. But if the court's question is this an adversarial proceeding, we're on filing number 213, I think. There are very few friendly actions that are 213. Everyone has been professional, but that doesn't mean this isn't adversarial. You know, we've been sitting by as, honestly, there have been a number of new arguments that keep coming up every 6 months, and we've sat there and we've dealt with this. We've raised our objections. And so to the extent there has been any prejudice, it's been universal. And so I don't know that it changes the course of these proceedings to that effect. And as for the legislator's process. If there's some inappropriate leak or something that shouldn't have happened, then there are other authorities that can enforce the rights of the government over whatever records there are. I'm not trying to say the court shouldn't do what it's contemplating, but I'm just saying there are separate other avenues for them to do that, and we'll just have to wait to see how that pans out. But in terms of does this prejudice the process going forward in such a way that prevents the court from issuing a relief or ruling on the merits, we don't think that it does, and we certainly don't think anybody needs to be added as a new respondent, right? Because he's not a petitioner, whoever this is. And I'm not prepared to argue the Rule 19 proceedings because that's the first time I've heard of that. But Metro hasn't asked for really any relief. They haven't filed a petition. So I don't know what relief they would get against him unless they're going to file another action. They're welcome to file another action. They have a whole slew of lawyers. They can file their own actions and do whatever they will to outside of the proceeding and the petition that we established to get these records published.
Okay,
Thank you.
thank you. All right. Anyone? Mr. Hollow?
Yes, thank you, Your Honor, the case to me appears to be a very straightforward issue, and that's the way it was framed when we began. There are records in possession of the government, i.e. the Metropolitan Nashville Police Department, which we contend are public records, and we have asked the court to agree with us and say, yes, they are public, and you may have access to them. Now, from that basic point, all of the rest of this has arisen, and part of that situation occurs because of the intervention. As the act was passed, I truly believe that it was intended to be A versus B. I have the records, you want the records, you say give me the records, I say I'm not going to give you the records, and we duke it out, and that's the end of it. But with the addition of the intervenors, and I'm not quarreling about the fact that they're here legitimately.
Their
The Court of
rights are
Appeals
vested.
has said so. Okay, so we don't argue that. It would be improper to do that. But that injects into that A versus B issue a collateral question. And the collateral question is, well, we're on the side of the person who has the records but doesn't want to give them to you yet because we have reasons that we believe are valid that supports their position. It's not the position of the possessor of the record's custodian, it's the position of the intervenors. All of that comes together, Your Honor, it's an amalgamation, and it's an issue that this court has to decide. And this court can decide that question without any consideration of anything beyond what's in the record right now. If somehow, somewhere, some of the information, which may or may not be an accurate depiction of what's in the record that Your Honor has for in-camera review, if some of that has somehow found its way outside the record here, that's another question. The two issues can continue in parallel, if you will, but the big issue is still the question of, are the records are public? Is there an exception that keeps that application from applying here? Are they subject to some kind of an exception? If so, what is it? And that's the issue. Then if someone else over here has taken something or has access to something, then you get into all kinds of problems. How did the person get the information? But as you see, the information is no longer in the possession of the person who acquired it. It's now gone to a third party beyond that. And that gives us a whole new host of constitutional implications. Because if I'm the media, or I'm engaged in publication for getting information for publication or broadcast, and someone gives me the information, look at Cox Broadcasting versus Kahn. Classic situation. No one was supposed to publish the name of a rape victim. But on the desk or on the counter, there is the report of this situation. Someone sees it, it gets reported. Do you then punish the media that published that information?
But is
The
this-
Supreme Court of the United States said, no, you don't. So it's a separate issue.
I guess, Mr. Hollow, the court struggles a bit because, you know, the petitioners are actually in this case subject to this court's jurisdiction, and so that makes it a little bit more nuanced, right? So the court
That's
has-
correct.
Yes, so the court has jurisdiction over these parties in this case, and so when an allegation arises that one of the parties in the actual case has done something, the analysis becomes a bit different and a bit more nuanced, and frankly, maybe a matter of first impression for this court and, you know, at least courts in Tennessee, because it is a bit more nuanced, because the allegations are that certain folks in this actual case, you know, are taking matters into their own hands. So,
Well, of course, again, that's beyond the record right now.
I understand.
And, I mean, really it is. And even if we have a declaration, that declaration doesn't stand for proof of anything. It stands for an allegation that someone says something happened, but it's not proof. And so we still are we're in a situation where we have the initial question, which needs to be answered, and if the initial question is answered in one way, then it may moot the second question. Your Honor has, you know, if Your Honor says, okay, you can have a look at them, produce the records, then what has transpired over here is moot for any purpose, except perhaps for the issue that one of the parties engaged in conduct which was in violation of the court's orders. And that's an entirely separate question.
All right. Thank you, Mr.
You're welcome, Your Honor.
All right. Did you want to speak, Mr. King, Mr. Clark? And then that will wrap up everything. I'm assuming that Mr. Horowitz and Mr. Berry will just wait for an order from the court, or I will give you a moment if you'd like to speak. Mr. King.
Your Honor asked the question, has there been any type of interference or abuse of this process under the Tennessee Open Records Act? Your Honor, that act is set up so when there is a request made and there is an objection that follows, the court acts as the arbiter of whether those documents are disclosed and whether they become a matter of public record. Obviously, Your Honor, that process has not been followed in this case. Obviously, a third party has wrongfully appropriated documents from Metro and provided those documents to media outlets, and those documents have been published. But, Your Honor, that does appear to be the collateral issue here. The salient issue is that the documents that rest within your possession, which I believe from what you've heard today, truly are more than the 80 or so pages that the Star boasts that they have in their possession from the individual that wrongly appropriated them, far exceeds what's out there. And, Your Honor, I believe that clarity on whether those documents that you still have in your possession that have not been disclosed to media outlets deserve a ruling on whether they are open records subject to production. The collateral issue of whether this individual that took action into his or her own hands flaunted Tennessee law in this process can be determined by other departments, other entities, and maybe even in a subsequent hearing in this case. But your ruling, Your Honor, will provide the first step of clarity of how these parties proceed and what action Metro will take. Your Honor, if you come forward and find that these documents are not in fact public records, I would likely wager that Metro will add additional layers of protection to ensure that these documents remained under seal and away from now. If they're not, Your Honor, Metro will have to come forward, subject to any type of appeal, and start producing those respective documents. So your ruling is literally the first step in this process. But to answer your question, initially, you were the one that was supposed to call the balls and strikes in this case. And someone divested you of that. I don't believe that should stall your decision. But that's the answer to your question, Your Honor.
Thank you, Mr. King. Mr. Osborne.
Thank you, Your Honor. It seems to me that all petitioners and all interveners agree that, we would like to have a ruling from the court on the merits. To your question about the impact that this has on sort of the rule of law, I certainly echo Mr. King's comments. And the reason I keep thinking about the Salinger case, Your Honor, is that I think there's a similarity here. Right now we know there's a copyright, and the question is whether or not copyright is an exception to the TPRA, which is what we are waiting for Your Honor's decision on. In that case, there was the question about whether copyright would prevent publication. And what we've essentially happened is that something that did not happen in that case, which is that instead of waiting for the judge's ruling, those copyrighted materials have been given to people and published. And we use the word unprecedented repeatedly in this case. And once again, Your Honor, I think this is unprecedented. Except to say that that's something I'm still wrestling with, and I think we will all be wrestling with. But your decision will ultimately either confirm there's an issue or potentially decide that there actually is not an issue when it comes to copyright. And so the level of challenge.
Okay.
Thank you.
Mr. Horowitz, do you have anything?
I do, but I need to know if whatever we're calling the proof in this hearing is closed before I do it.
So I don't know that the court really took any proof per se, other than to hear from the folks in the underlying case as to what the landscape is. And, as I said before, this court did not go and do its own separate investigation. I did not go and look at any websites. I don't watch the news, so when I was informed that there was perhaps an issue in this case, the best thing for me to do is to hear from the folks involved and then see what next steps need to be. So,
And I appreciate that, Your Honor. I just need to know if that portion of this process is closed before I...
well, that is going to be the process for today. So if you plan on bringing in other arguments, the court is not going to entertain that because I have accomplished my purposes for today. And should there need to be a separate hearing after the court issues, a ruling on this particular matter, your counsel of record, you will get that ruling, and then we may be back here. So I guess my question for you is, do you plan on speaking to what has already been spoken?
Yes.
Or do you plan on raising a separate issue?
I will speak to what's already been spoken on, and I just want to retrace the chronology of how we got here because I think it matters for the record if and when we have to do more elsewhere. This court's order on Monday last week said that this court sets a show cause hearing to determine why the alleged publication of certain purported documents by petitioners Star Digital Media and Michael Leahy as editor-in-chief does not...
Mr. Horowitz, I'm aware of my order. Should this matter go up on appeal, the Court of Appeals will get the whole entire record. Again, I am going to truncate your argument. You can take it up on appeal if you need to. But unless you are speaking to the underlying issue of whether or not there is still a justiciable issue for this court to review, if you'd like to speak briefly on whether in your limited appearance your client feels that there is abuse or unlawful interference with this process or proceedings, I will allow that. But I really, again, as I said in the order denying your motion to set aside, your arguments aren't ripe yet. And I'm not saying that they won't become ripe, again...
Your Honor, I just need to be heard here. And if
Well,
I
I'm-
need to make a record here, then this is my offer of proof. But we were initially ordered to be here to show cause why Mr. Leahy did not violate orders of this court. This court has not identified any such order that was violated, neither has any party.
That is because we are not having those proceedings today. So,
And I-
Mr. Horowitz, if there isn't anything else, thank you so much. And
There is,
you
Your
get-
Honor. This court then expanded the order that it put down to say that it was going to inquire into alleged violations of orders or Tennessee's general contempt statute. And then everyone got up in here today and all of the parties agreed. No party maintained that Mr. Leahy or the Tennessee Star violated the contempt statute or violated any order of this court. We'd ask
But
that today.
again, Mr. Horowitz, I've not necessarily heard anything on that. I really needed to just get the lay of the land. I have the lay of the land. I will determine, based on what I've heard today, in a subsequent order, whether or not there will be other proceedings. And so, again, I understand your desire to educate the court on your client's position. It simply is not ripe yet. And I am not saying that it will not become ripe. But for right now, I have the information that I need. If you would like to confirm and or deny that perhaps your client, did what the allegations, at least out there, outside of the record are, I guess I am happy to entertain that, but there are certain rights that have to attach to your client.
What I would like to confirm.
And I have not put down an order which delineates those rights, which before I can have any subsequent proceedings on contempt or show cause or anything like that, those rights have to be distilled down to an order. So I want to ensure that your client, should there be subsequent hearings in this matter, that your client has all of his rights and its rights as set forth in the case law and in our statutory schematics, so that he can come into court and properly do what he needs to do. And we're simply not there yet.
What I need to confirm before I close today is what cause my client has been ordered to show. It sounds like the evolution of this proceedings is none, that he has no obligations today, doesn't have to prove anything. If that's the case, I'd ask you to close down the contempt proceeding or the threatened sanctions.
Well, there is not, as I said before, Mr. Horowitz, and then I will ask you to sit down. In my subsequent order, there is not a contempt proceeding today. If you had read in
I recognize there's
detail-
not a contempt proceeding, Your Honor, but there is
Yes.
still a show cause proceeding, and I
Well,
don't know
you
what
know-
cause you were asking me to show.
So right now, I have heard from the parties the information that I need to know. If there is a subsequent show cause proceeding, I will ensure that it is delineated in a very clear and crisp manner so that your client can prepare with you, his counsel, and come in and show whatever he needs to show. But before I can do that, I had to get an understanding of the landscape. I have that understanding now. I will distill these proceedings to an order of the court wherein you and your client can take next steps if need be. Okay?
Thank you, Your Honor.
Thank you. All right. Thank you all so much for coming in today. I really appreciate the lawyers coming in and having a colloquy with me and educating me on the landscape of these proceedings. As I stated earlier, my opinion, however long, 60 plus pages, was getting ready to come out on Friday, but due to the information that was set forth with the court, I needed to call everyone in to see where we were. Now I have an understanding of where we were. I will issue a ruling. Everyone will be on the same page once my ruling comes down. All right? I appreciate your time today, your patience, and thank you, Mr. Leahy, for coming in individually. All right, you all are dismissed.
All right.
Court is is adjourned.